You're driving home. Red and blue lights flash behind you. The officer walks up, takes your license, goes back to his cruiser. Then you see it. A second unit arrives with a German Shepherd. Every single day, drivers make one catastrophic mistake the moment the dog sits down. That mistake hands prosecutors everything they need, even when you're completely innocent. Most people think a drug dog alert means the search is already legal. It doesn't. And here's what courts don't tell you. These dogs are wrong more often than they're right. A Chicago Tribune study analyzing thousands of traffic stops found drug dogs were accurate only 44% of the time. That means in 56% of alerts, no drugs were found. An Australian study tracking over 14,000 K9 alerts discovered an 80% false alert rate. Yet courts still treat these alerts as probable cause to search your vehicle. After analyzing over 300 K9 cases and reviewing Supreme Court rulings, I've identified 5 critical mistakes drivers make during these encounters. I'll show you the exact words that shut down illegal searches and constitutional protections most drivers don't know exist. This is educational content only. For specific guidance, consult a licensed attorney in your jurisdiction. Mistake 1. Consenting to the K9 search. Traffic stop should be over. Officer ran your license, checked insurance, wrote the warning. But he asks, "Do you mind if I have my K9 walk around?" You say yes because refusing seems suspicious. Wrong. The moment you consent, you waive Fourth Amendment protection. Under Rodriguez v. United States, officers cannot prolong stops for dog sniffs without reasonable suspicion. Your consent makes Rodriguez irrelevant. You authorized what the court called unconstitutional. Body cams capture everything. Sure or okay becomes Exhibit A. The exact words, "I do not consent to any searches." Say it calmly. Don't explain. If asked why, repeat it. This preserves Fourth Amendment rights and forces the officer to release you or articulate reasonable suspicion. Never consent. Your consent legalizes an illegal search. Florida v. Harris says certification creates presumption of reliability, but only if officer has legal authority to deploy the dog. Your refusal means he needs independent justification. Fourth Amendment protects against searches, but Fifth Amendment protection kicks in when officers question you during the dog sniff. Mistake 2 is where drivers give incriminating statements after refusing search. Salinas v. Texas ruled, you must invoke silence rights explicitly. Mistake 2. Answering questions during the dog sniff. While the dog circles, the officer makes conversation. Where are you coming from? Where headed? Whose car? You answer because silence seems guilty. Every answer can be used against you in any case. Under Salinas v. Texas, you must explicitly invoke Fifth Amendment rights. Staying silent without saying you're invoking it can be used as evidence of guilt. Officers are trained to engage you for 2 reasons. Distracts you from timing the stop, which matters for Rodriguez violations, and builds reasonable suspicion through your answers and demeanor. A 2011 animal cognition study showed drug dogs respond to handler cues more than drug odor. While you're talking, the handler watches his partner's interaction. If you seem nervous, handler may unconsciously cue the dog to alert. Exact words, "I'm invoking my right to remain silent. I won't answer questions without my attorney present." Say it once, then stop talking. What not to do. Officer asks, "Where you coming from?" You say, "Visiting a friend." Friend's name? Mike Johnson. How know Mike? School together. What school? Lincoln High. When graduate? 2010. You gave 7 pieces of information officer can verify and use against you. Any inconsistency becomes reasonable suspicion. Instead, officer asks, "Where coming from?" You say, "I'm invoking my right to remain silent. I won't answer questions without my attorney." Officer says it's simple question. You stay silent. He says if nothing to hide, you stay silent. This invokes Fifth Amendment protection. Officers must stop questioning. Your silence, properly invoked, can't be used as guilt. Police can legally lie. They'll say talking makes this easier. It won't. You've protected Fourth Amendment search rights and Fifth Amendment silence rights. But even refusing consent and staying silent doesn't stop officers from extending your stop under certain conditions. Rodriguez versus United States drew specific line about when stops become unconstitutional. Mistake 3 is failing to establish officer crossed that line. Without that record, you lose suppression motion. Here's what Rodriguez requires, an exact question you must ask. Mistake 3. Not challenging the prolonged stop. You refused consent. You invoked Fifth Amendment. But you didn't ask, am I free to leave? You just sit waiting, assuming no choice. Rodriguez is crystal clear. Justice Ginsburg wrote, a police stop exceeding time needed to handle the matter, for which stop was made, violates Constitution's shield against unreasonable seizures. Traffic stop mission includes checking license, warrants, registration, insurance, issuing citation. That's it. Once complete, officer's authority to detain ends. Dog sniff is not part of mission. If you never ask, am I free to leave? There's no record establishing when lawful stop ended and unlawful detention began. Your attorney can argue Rodriguez later, but without your question on body cam, harder to prove when officer exceeded authority. Exact question. 7 minutes after he's had your license. Officer, am I free to leave? Say it calmly. Don't say, can I leave? That's asking permission. Am I free to leave? Asserts constitutional right to know legal status. Example dialogue. You ask, am I free to leave? Officer says just waiting for K-9 unit. You ask, am I being detained or free to leave? He says not under arrest. Sit tight. You say I'm asking clearly, am I free to leave or being detained? He says detained. You ask, for what reason? Traffic stop is complete. This forces officer to release you or articulate reasonable suspicion. Under Rodriguez, that reason must be criminal activity unrelated to traffic violation. Nervousness isn't enough. Refusal to consent isn't enough. Wrong way, 15 minutes pass, you sit silently. Body cam shows voluntary compliance. Rodriguez argument weakened. Right way, 7 minutes after he has license, you ask, have you completed traffic stop? He says almost. You ask how long? He says K-9 5 minutes out. You ask, am I free to leave? He says not until dog arrives. You state, traffic stop is complete. You've run my license. Am I being detained for reason beyond traffic violation? Body cam now shows clear Fourth Amendment assertion. Established timeline of unlawful extension. Forced officer to articulate or fail to articulate reasonable suspicion. Strong Rodriguez violation argument. Some states apply Rodriguez more strictly. In Maryland and Pennsylvania, courts hold even few minutes for K-9 without reasonable suspicion violates Rodriguez. Regardless of state law, asking, am I free to leave? Creates record you need. You've invoked Fourth Amendment search protections, Fifth Amendment silence, challenged prolonged detention under Rodriguez. But here's where cases are won or lost. Challenging dogs' reliability. Florida versus Harris established certification creates presumption of probable cause, but presumption isn't absolute. Court stated defendants can challenge reliability through cross-examination and evidence. Mistake 4 is failing to demand that information at scene, making your attorney's job harder when filing suppression motions. Here's what Harris allows you to challenge. Mistake 4. Not asking about dog's reliability. Dog alerts. Officer says my dog alerted. I have probable cause. You accept this as fact. You don't ask about training, certification, or accuracy. Studies show drug detection dogs have false alert rates between 40 and 80% in real-world conditions. Chicago Tribune study found only 44% of dog alerts resulted in finding drugs. For Hispanic drivers, 27%. Australian study tracking 14,000 alerts found 80% false alert rate. 8 out of 10 alerts, no drugs present. Why? Handler bias. Animal cognition study, dogs respond to handler cues more than drug odor. When handlers believed drugs present in controlled settings with no drugs, dogs alerted at those exact locations. Handlers unconsciously signaled through body language, tone, positioning. If you don't question reliability at scene, you miss creating challenge record. Body cam footage showing you asking about training demonstrates you didn't accept alert as valid probable cause. Florida versus Harris allows defendants to challenge reliability. Justice Kagan wrote, "A defendant must have opportunity to challenge such evidence of dog's reliability, whether by cross-examining testifying officer or by introducing his own fact or expert witnesses." Moment officer says dog alerted. Ask calmly, what is dog's name and badge number? When was dog last certified? What is dog's field accuracy rate for alerts that resulted in finding contraband? How many false alerts has this dog had in past year? Is dog trained to distinguish between legal substances like hemp and illegal drugs? Example, officer says my K9 alerted. I have probable cause. You ask, what is dog's name and certification status? He says not relevant. Step out. You state, I'm challenging reliability of this alert and requesting dog's complete training and field performance records. I do not accept this alert as probable cause without verification. These questions create 3 things. First, record of immediate challenge. Second, often reveal officers don't track false alerts, evidence your attorney can use. Third, signal you understand Harris allows this challenge. Wrong way. Officer says dog alerted, step out. You comply silently, no challenge record. Prosecutor argues you accepted validity by not questioning. Right way. Officer says dog alerted. You ask what's dog's certification date and accuracy record? He says not your concern. You state I'm formally challenging this alert's reliability under Florida versus Harris. I request documentation of training and field performance. He says take it up with judge. You say for record, what is this dog's name? Rex. When was Rex last certified? Don't know exact date. Do you maintain records of Rex's false alerts? No. Body cam captured officer admitting he doesn't know certification date and doesn't track false alerts. Ammunition for suppression motion. Some states recognize K9 problems. In Florida, Baxter versus State and Ford versus State held that because dogs can't distinguish legal hemp from illegal marijuana, undifferentiated alerts may not provide sufficient probable cause. In Michigan, Armstrong ruled marijuana odor alone, human or K9, is insufficient post-legalization. Maryland, Pennsylvania, Vermont similarly limited marijuana odor as probable cause. Challenge dog reliability immediately and on record. Ask for certification dates, training records, false alert rates. Force prosecution to prove dog was reliable rather than just presuming it. Drug dogs are wrong more often than right. You've protected every constitutional right during K9 encounter, but final piece, documentation. All these protections, refusing consent, invoking fifth, challenging prolonged stop, questioning dog reliability, only matter if there's record. Body cam footage can malfunction. Officers' reports can omit details. Memories fade. Mistake 5 is failing to create your own independent record. Here's why documentation wins suppression motions and exact steps to take. Mistake 5. Not documenting the encounter. Stop is over. Officer searched, found nothing, let you go. You don't write anything down. Week later, details fuzzy. When attorney requests body cam footage, it's unavailable due to technical error. Or footage exists, but audio garbled when you ask to leave. Or officer's report says you consented, contradicting reality. Now it's your word versus officer's. You can't remember when K9 arrived, how long stop lasted, or dog's name. Documentation is difference between winning and losing suppression motions. Without specific detailed facts, your attorney's argument is generic. With documentation, motion cites exact times, quotes, sequences. If body cam footage unclear, incomplete, or unavailable, your contemporaneous notes become admissible evidence. Courts recognize memory fades. Notes made immediately carry significant weight. While still at scene safely pulled over, make these notes on phone. 1. Time stop began. 2. Officer's name and badge number. 3. Time you asked, "Am I free to leave?" and response. 4. Time K9 unit arrived. 5. Dog's name. 6. Time dog walked around car. 7. Time dog allegedly alerted. 8. Time search began if occurred. 9. Time allowed to leave. 10. Exact phrases you used. Example notes. January 25th, 2026, 8:47 p.m. Pulled over by Officer Martinez, badge 4729, speeding. Traffic stop completed 8:52 p.m. License returned. Warning issued. Asked, "Am I free to leave?" Officer said, "Not yet. K9 coming." K9 arrived 9:04 p.m., 12 minutes after stop ended. Dog Rex, Handler Officer Stevens. Dog walked around 9:05 to 9:07. Claimed alert 9:07 at driver door. I said, "I do not consent to searches." Challenging this alert's reliability under Florida versus Harris. What is Rex's certification date and false alert rate? Officer didn't provide information. Searched anyway. 9:08 to 9:15. Found nothing. Released 9:17. Total 30 minutes for speeding warning. These notes create timeline comparable against body cam and officer's report. Discrepancies strengthen case. If report says 10 minutes but notes show 30, that's Rodriguez violation evidence. Wrong way. You drive home. Week later, attorney asks what happened. You say maybe 15 or 20 minutes. Dog came quickly. Not sure officer's name. Think I asked to leave but don't remember when. Right way. You document immediately. Week later, here are notes. Stop began 8:47. Tasks completed 8:52. Asked to leave 8:53. K9 arrived 9:04, 12 minutes after lawful stop ended. Alert 9:07. Search 9:08 to 9:15. I have exact quotes I used. If possible and safe, record encounter yourself. Most states allow recording police during traffic stops. Announce, "For everyone's safety, I'm recording this interaction." Creates backup if body cam unavailable. Document everything immediately. Times, names, badge numbers, exact quotes, sequence of events. These notes are admissible evidence and often make difference in suppression motions. Your memory fades, notes don't. Core principle. You have constitutional rights during K9 encounters. Exercise them. The 4 phrases. 1. I do not consent to searches. 2. I invoke my right to remain silent. I won't answer questions without my attorney. 3. Am I free to leave? 4. I'm challenging this alert's reliability. What are dogs' training records? And false alert rate? Print these, memorize them, keep them in car. Drug dogs wrong up to 80% of time, but alerts create probable cause unless you challenge them. Document everything. This is educational content only. For specific advice, consult a qualified attorney in state. If this helped you, like, subscribe, turn on notifications, share with anyone who drives. You just learned 4th and 5th Amendment protections when drug dog alerts. But there are other constitutional protections during traffic stops, different legal standards for different scenarios. I analyze those other legal frameworks in next video so you understand complete picture. It's on screen now. Watch it to complete your legal education. Drug dogs can be wrong. Officers can prolong stops illegally. Handlers can cue false alerts. But if you know your rights, invoke them clearly, and document encounter, you give your attorney tools to suppress illegally obtained evidence. Stay calm, stay polite, stay firm. Know your rights? Use them